Welcome to Law&Crime's Daily Debrief. The defense has the case and is presenting witnesses in the Harvey Weinstein sex crimes trial. Law&Crime's Jesse Weber has been in that courtroom for us here in Manhattan.
Elizabeth Loftis, a psychologist and distinguished professor who specializes in memory. The judge ruled that she would be limited in what she could testify to. She could discuss memory generally, but not specifically sexual assault cases or any facts of this case in particular. Now, she talked about the 3 stages of memory: acquisition, retention, retrieval, and how there are certain factors that affect the accuracy of one's memory. First, she said that obviously memory fades over time, but maybe more interestingly, that memories are susceptible to something called post-event information. This distorts memories or creates contaminated memories. Anything from suggestions to leading questions to media coverage to therapy, which are all issues in this case. This can all affect how one remembers an event. She also said that if someone remembers something in a way to help someone else or to satisfy a situation, then someone might remember something and it feels like a memory, but it's really not a true memory. Dr. Loftis said it's possible that one can plant entire events into the minds of ordinary people. And then maybe more specifically to this case, if you label something one way, it can affect how you remember that event. The bottom line here, and the insinuation made by the defense, is that these accusers' memories are not reliable. Not about them even lying, but that they're relying on misinformation, that they were fed information, and that their memories were contaminated. Now, under cross-examination, Jonah Luzzi basically said that this witness tailored her testimony and responses based upon the facts of this case. She specifically cited how Dr. Loftis, when asked a question about prescription medications' effect on memories, mentioned Valium. And out of all the prescription medications that Dr. Loftis could have mentioned, why'd she mention Valium? Now, we know that Valium came up in the Annabella Shura account, to which Dr. Loftis conceded that she did read something about Valium in regards to this case, which again makes her look like she's tailoring her testimony to help the defense. And speaking of that, Jonah Luzzi alluded to the fact that this witness is biased in helping the defense. In fact, at one point, she said, "You wrote a book called Witness for the Defense. Did you ever write a book called Witness for the Prosecution?" No, she did not. The second witness today, and the final witness today, was a forensic document examiner who was tasked with analyzing Miriam Halay's calendar and those cross-offs that she allegedly made in regards to Harvey Weinstein. That helps to strike her credibility, because the question is, what was she hiding? It was an interesting day. We expect more on Monday, so we'll have to see what happens. This is Jesse Weber reporting for Law&Crime.
We need to jump in with some breaking news right now. We're following the penalty phase of the trial of convicted killer Donald Hartung. A Florida jury there handing down a verdict as we speak. In the penalty phase of the case, this is a defendant accused of killing his mother and brothers. He was convicted of those crimes. The judge is looking over the verdict sheets as we speak, live here on the East Coast if you're watching the debrief on the Law&Crime Network. So let's jump in with some analysis here about this case as we wait for this to be read. Michael Bryant, Catherine Smith in studio with me. What do you think, death penalty, Michael, or life in prison?
I think it's going to be tough to avoid the death penalty. The mental mitigators we heard about were just not enough.
Here we go. Let's listen.
15 CF 004806A, Division C, Danheiser. Jury verdict form, death penalty. We, the jury, find as follows as to Donald Hartung in this case. Section A, aggravating factors as to count 1, Bunsell Smith. We, the jury, unanimously find that the state has established beyond reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in cold, calculated, and premeditated manner without pretense of moral or legal justification. No. Aggravating factors as to count 2, John Smith. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in cold, calculated, and premeditated manner without pretense of moral or legal justification. No. aggravating factors as to count 3, Richard Smith. We, the jury, unanimously find that the state has established beyond reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for a pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. No. Section B, sufficiency of the aggravating factors as to count 1, Bonsil Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Sufficiency of aggravating factors as to count 2, John Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Sufficiency of the aggravating factors as to count 3, Richard Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Section C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Section D, eligibility for the death penalty for count 1, Bonsil Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established in Section C above as to count 1, Bonsil Smith. No. Eligibility for the death penalty for count 2, John Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established in Section C above as to count 2, John Smith. No. Eligibility for the death penalty for count 3, Richard Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond reasonable doubt, Section A, outweigh the mitigating circumstances established in Section C above as to the count 3, Richard Smith. No. Dated this 7th day of February 2020 in Escambia County, Florida, foreperson Jennifer Dulos.
Please be seated. Are there any requests of counsel?
No, Judge.
All right. Members of the jury, we all appreciate your extreme dedication. There's no more serious or draining case for a jury than a case of this nature. We've taken the better part of a month of your lives, and we understand the sacrifice you've given, but it's necessary for the judicial system to function properly, and our due process guaranteed by the Constitution.
And there is the ultimate recommendation from that Florida jury. This will be life in prison for Donald Hartung. It looks like Michael Bryant, Catherine Smith in studio with me here. We were shocked because we thought in a case like this, there were elements of premeditation. You've got elements of viciousness rather. And Catherine, here the jury just didn't go for the death penalty.
I'm genuinely surprised because if they reached the response that they did on liability, which was weighing all some of the suspicious evidence that was brought in and how the investigation was done, they still got to liability. So I really don't reconcile how they got to death or no death on this.
Michael Bryant?
You know, they actually paired out, was it cold and calculated? No. They said no to each of the deaths. They were not cold and calculated. Those were critical aggravating factors. I'm amazed.
Let's jump in with our panel watching remotely right now. Joseph Scott Morgan, forensic death examiner, Dina Dahl, attorney and mediator. So Dina, your thoughts on this? It's a bit of a shock to me.
Actually, I thought he might not get the death penalty, only because, you know, they're all adults here for one thing. There was not a child involved. And although they made it clear that he committed the crime, I don't think they really made it so clear why. There was obviously conflict in this family, and maybe it was a spur of the moment, heat of the passion. I actually think that it made sense.
Joseph Scott Morgan, your analysis, your reaction to this.
I think one of the most striking things about this case, Aaron, is that he showed up prepared. You know, he had a handgun, he had a knife, he had a hammer, and so it goes beyond, you know, a heat of the moment, the heating and cooling of blood, if you will, as some statutes read, and it seems like he was prepared to go forward with this. I'm a bit surprised in this case.
I think many of us are, but sometimes mercy does win the day in a court of law. We have a lot to talk about tonight, though, here on The Debrief. Connecticut defendant Michelle Troconis today pleaded not guilty to charges she conspired to murder her former boyfriend's wife. Jennifer Dulos disappeared last May, and her husband Fotis was suspected of killing her with help from his girlfriend Michelle Troconis and his friend and former attorney Kent Mawhinney. Fotis Dulos killed himself, but the cases are remaining against the other defendants. Troconis entered court today in Stamford, Connecticut with her new attorney, John Schoenhorn. She fired her old attorney this week. Aside from the not guilty plea, Schoenhorn filed a motion to move the case to Hartford in central Connecticut and away from Stamford in the southwestern tip of the state. The judge today ordered Troconis to remain on house arrest, but she can leave for basic needs like grocery store trips and can also leave for work appointments if she seeks prior approval. The prosecutor said he was concerned that Troconis had been trying to talk to Fotis Dulos before he died.
He said that she's been a resident of Connecticut for 2 years. That's correct. She's lived with Fotis Dulos. She, at some point in time, ended that relationship, but I did hear, Your Honor, that she was having contact with him through a third party. I'm still trying to confirm that in violation of the conditions of her release.
Just very briefly, we know nothing about third-party contact. It's certainly not anything that, if somebody was trying to contact her, that is not something that I think, especially the suspicion, is anything can be attributed to her. Whether or not there was efforts to reach out to her through third parties, it wasn't something that came to her attention. Nobody really even has her phone number, so she's not allowed to leave her house.
Also in court, the defense talked about the amount of money Troconis' family had to put up in order for her to make bond and remain free before trial.
I also know her mother, who's a psychologist in Florida, has moved up and is living with her. She has a practice, but she's been staying with her up until now because she's not allowed to even go shopping. The amount of money, the parents posted all their property. If she were to flee, they would lose everything. So I think that's something the court can take into consideration. I know for a fact, I spoke to the bail bondsman. He has secured the entire $2.1 million with property owned by both his parents. Father's a doctor, a cardiologist, and mother is a psychologist.
Troconis appearing there in court with an interpreter for the first time over the duration of these proceedings. Troconis' attorney also denied claims that Troconis, was communicating with Fotis Dulos before he died outside court. Her attorney said this.
Today was just about loosening the restrictions on her house arrest. We have postponed until March 20th consideration of any other motions that will be pending or are already pending. Perhaps that will be when we discuss the change of venue, that is moving the case to the Hartford Judicial District. Other than that, it was more of a first court appearance. Michelle pled not guilty today on the most recent charges and asked for a jury. And until I've reviewed the material that were just given to me, and that's why I brought this large briefcase, I have no other comment because I don't know enough to say anything other than what I've said before. Michelle is innocent of these charges, and we plan to fight them through the courts. Thank you very much.
Can you share any reaction to the death of Fotis Dulos from Mr. Troconis?
No, I would say that that's not appropriate.
Mr. Troconis, is there anything you want to...
And still ahead tonight here on The Debrief, the defense having the case of the killing of a young Dallas mother. Officers approached the car she was sleeping in, and as the car began to move, 2 officers began to fire. Police testify the shooting was justified after this. Day 4 of testimony in the Texas case against an on-duty Dallas police officer who fired his weapon while he was on duty and killed a young woman. Officer Christopher Hess fired 12 times and killed 21-year-old Genevieve Dawes. The charge is aggravated assault by a public servant, and it carries a possible 5 to 99-year prison sentence. A neighbor called 911 because Dawes and her partner were sleeping in a car. Police say they were suspicious because at one point the vehicle was reported stolen. The vehicle tried to take off by backing up, driving forward, and then backing up again. Officer Hess says he fired in self-defense or to protect other officers on the scene.
What's up?
Alpha 143, check out major 2403 North Washington. Black male refusing to stay away from property. On a black shirt, black pants with red on the and a backpack.
Back up.
Have you around the like security, their uniform and armed?
Don't move! Hands up! Shots fired! 4700 east side, back parking lot.
Cover code 3 Alpha 140, can you hit that way? 4700 east side, shots fired.
Stop me an ambulance. Alpha 114, they rammed the squad car twice.
The defense wanted to call the victim's common-law husband to testify. Remember, he was in that vehicle and survived. That request resulted in an argument over whether the prosecution should grant him immunity to prevent him from pleading the Fifth.
While I'm doing that, Mr. Lewis, do you intend on offering him immunity today to testify?
No. Your Honor, so the record is clear, that would mean that the state offered him immunity to testify on their behalf to the grand jury on these same matters, but they are intentionally refusing to do so, knowing it will prevent the jury hearing his testimony, and it means we cannot call him as a witness.
And that violates the 14th Amendment.
Okay. All right. You can go back. Thank you, Mr. Rosales.
The state has refused to grant immunity because the state thinks he might have criminal liability in the event we want to talk about, and they may want to prosecute him later for it.
I disagree with that. There's no evidence or proof of that. Both what you and what Ms. Madsen have said is making an inference and a supposition based on their refusal to grant immunity, and I cannot sponsor that. You all may be right, but I can't sanction that and say you are right.
Some officers at the scene testified for the state. Several others testified for the defense to say they thought the shooting was justified.
Yeah. Okay, let's go to the point the shots were fired. Where were you at?
I would believe I was behind the squad car near this tail light for the driver's side building.
And do you know where Officer Hess was?
I could clearly read his back patch, so he was in front of me and to the left a little bit.
Okay. As that vehicle was going back, at that point in time, do you still believe officers are behind that vehicle?
Yes.
Did you have your gun drawn?
Yes.
Did you fire your gun?
No.
Why did you not fire your gun?
I had a squad car and Officer Hess between me and the suspect vehicle.
Okay. Would that have been a dangerous thing to do?
Yeah.
Why?
Well, because I accidentally shot an officer, I could have violated policy.
If Officer Hess was not in front of you, would you have fired your gun that day?
Yes.
Why?
Because there's a huge threat to all officers behind you.
Okay, let's jump in for some analysis on this one. Forensic death examiner Joseph Scott Morgan. Joseph, your analysis of this one here. I listened to that video and I hear the officers say back up, and then the vehicle backs up, and then they say stop, and then they open fire right away. Is it possible that the command to back up was something that the people in the vehicle heard and thought it meant them, not the other officers at the scene?
Yeah, sure. I guess we could go down that line of logic to say that is a possibility if they could hear him say that. I don't know if he's giving that as an indication to his colleagues there that they're backing up, and it's a bit confusing. So I think that's a big question here, Aaron. This whole scene is very confusing as to why such level of force was deemed necessary, particularly given the fact that the officer that fired all of these shots was not in the line of attack of the car if the car had been weaponized.
Dina Dahl watching from California, attorney and trial mediator. Dina, is this justified in your stance, in your belief from where you sit?
You know, it was definitely a chaotic scene. And so I could see the police being like hair trigger, because we see with, Trooper Casey, there are situations where a police officer is going to get shot and it's not always leading up obvious. To be honest, I want to see more details on this case. I think it's going to be a very close call.
Do you think it's interesting, Dina, that so many officers are testifying, well, I believe that this was justified? Because whenever you start hearing that, it's almost like, in my opinion, an attempt to focus the jurors on everybody's opinion and not what the law actually says.
Yeah, exactly. Because all of them could believe that it was justified, and it doesn't matter, right? It only really matters what that particular officer has, the information he was taking in, was that justified in believing in this action.
I want to switch over to our guests with me here right now in New York. Catherine Smith, you're shaking your head as you watch that footage roll by, so it seems like you have some serious issues here.
I have some serious issues here. And first of all, it's what a reasonable police officer under the circumstances would have perceived as a deadly threat. This was a car backing up. Let's just say worst case, a stolen car going backwards to 2 to 5 miles per hour, not even in the path of any of the officers. That creates a terrible precedent that we could use deadly force on anyone operating a vehicle that way.
I thought the same thing when I watched this, and I think that ultimately the jury's going to make its decision based on what's in that video, and not so much on everybody's opinion, not so much on any other forensic evidence or whatnot. It's just a question of whether or not there was a reasonable fear of death here or serious bodily injury.
I just don't see it.
Michael Bryant.
Yeah, you know, it's going to come down to not just the video, but the two things that are most important in the video. The speed of that car backing up, to agree with Katie. Of course, who knows how quickly it could have accelerated. And the number of shots fired. I really believe that if Hess had fired once, twice, maybe we wouldn't be here. Maybe it'd be a similar situation to his fellow officer who fired once and hit the vehicle. We don't know. It's over now. We're looking at it in the rearview mirror. But those two factors are key. How fast did the car move? How many shots were fired?
Joseph Scott Morgan, let me jump back over to you here. When you look at the forensics of this, I mean, what happens with what we see in the movies where they fire and pop the tires or something like that?
No, that's not something that's done. Maybe in a high-speed chase, they're going to put out spikes. And if they're chasing a vehicle and there's imminent danger to the public, you might see someone fire a shotgun out the window to try to render the vehicle inoperable. But in a case like this, no, I can't see it. And, you know, you think about, to Michael's point, you know, this vehicle is not moving very fast. The officers are standing back. I don't understand it. It's beyond the pale, because when you think about it, there is a force continuum that the police officers have to adhere to. Okay. And so their standard is much different than, say, if it was a civilian out there. And it just doesn't make sense to me.
So from your perspective, Joseph, you don't think that this is justifiable?
No, I don't see that as being justifiable.
You know, so many of us seem to have that opinion here at the Law and Crime Network, but the jury may say it differently because they're the one listening to everything in that courtroom. Dina, Joseph, thanks a lot. Thanks a lot, Michael and Catherine, for your thoughts here in studio in New York. We need to wrap things up on this brisk edition of the Debrief. I'll be back here at 5 o'clock on Monday, as well as Monday morning, because Jesse will be in the Weinstein courtroom.